एवरीवन, इस वीडियो में मैं आप लोगों के साथ दिल्ली जुडिशियल सर्विसेज एग्जामिनेशन मेंस का पेपर डिस्कस करूंगी। DGS 2022 मेंस एग्जामिनेशन एंड फर्स्ट क्वेश्चन पेपर इज़ जनरल लीगल नॉलेज एंड लैंग्वेज। मैक्सिमम मार्क्स 250। Section 1, General Legal Knowledge. Write short note in about 200 words on any 6 of the following. Let's see what are the topics. The administration of GST and its benefit to the central government. Highlights of the recent Karnataka High Court's hijab verdict. The refugee problem and the provisions of international law. The petition filed by the Shahbano and the significance of the verdict and the order given by the Honorable Supreme Court in 1985 judgment. Armed Forces Special Powers Act 1958. Weapons of Mass Destruction Amendment Bill 2022. Split verdict of Delhi High Court on 11th May 2022 on marital rape and two different viewpoints of the judges. The new liquor policy of Delhi government, the major changes and what they mean for the vendors and consumers. So there are total 8 topics and short note is to be written on any of the 6 topics. Next question. Specify whether the following statements are true or false. The Kothari Commission was set up to make recommendation for the safety and protection of children. 2 of the major recommendation of Justice Verma Committee were police reforms and Bill of Rights for Women. The first women advocate of India was Anna Chandi. In August 2020, Advocate Prashant Bhushan was fined ₹1 by the Supreme Court for criticizing the Supreme Court and the judiciary. The FIR Aapke Dwar Yojana has been launched by Delhi Police. Part 3rd of the Constitution is described as the Magna Carta of India. Article 21A prohibits religious instructions or any worship in educational institution maintained by the state. Quorum is the maximum number of members of a legislature that must be present to make the proceedings valid. Soli Sorabji has been appointed as the Attorney General of India thrice. The first Federal Court of India was set up in Delhi in 1937. So these are total and each question is of 2 marks. Next question, third question is answer the following questions very briefly in few words or in a sentence. What is the issue dealt with in Roy versus Wade judgment? What was the Delhi Municipal Corporation Bill passed by the Lok Sabha in April 2022? In May 2022, what was the Supreme Court's verdict regarding the COVID-19 vaccination and which article did it quote as the basis for its ruling? Name the 2 judges who were elevated to the Honorable Supreme Court in May 2022. Where are the headquarters of International Criminal Courts located? Which 2 judges were responsible for introducing PIL in Judicial System of India? What was Supreme Court order regarding the sedition laws as pronounced on 11th May 2022? Who has authored the book We the People? Who was the author of the book My Tries with Justice? When is the National Law Day or the Constitution Day observed in India? And next section is of language, and these questions were total also 10 and each question was of 2 marks. Next section is of language section. Write an essay in 500 words each on any 2 of the given topics. And the topics are an education system divided by internet, inequity during the COVID-19 pandemic and its long-term impact on India's youth and economy, Next, nothing is impossible if there is a political will. Next, social media is making us a social. There is no better test of excellence of a government than the efficacy of its judicial system. In 2021, India slipped 28 places to rank 148 among 156 countries in the World Economic Forum's Gender Gap Report 2021. What does this mean for India and how can this gap be bridged? So these two essays are of 25 marks each, so total 50 marks. Next question, write a précis of the following passage in about 150 words with a suitable title. So this is relating to précis writing. Next is translate the given extract into Hindi, and this has to be translated. This question is also of 30 marks. Next question is translate the given extract into English, and this is also of 30 marks. Next question is fill in the blanks in the following passages, sentences, choosing the most appropriate word from the given choices. This is relating to the fill in the blanks question. And this was the language paper. So now come to the next question paper, and this is Civil Law 1 question paper. Let's see first part. Write short note on any 4 of the following 6 questions. Whether a bequest of a property under a will would amount to transfer of property under Section 5 of Transfer of Property Act 1882. Explain. Next, property in the goods and risk in respect of them go together. Are there any exception to this principle? Explain with the help of the case law. What are the rights of the unpaid seller? Distinguish between the unpaid seller's right of lien and right to stoppage in transit. Support your answer with the help of examples. What is heritable property under Muslim law? Compare the same with the Hindu law in reference to ancestral property of Hindu joint family. An owner of a plot of land is building a 4-storied house within the jurisdiction of South Delhi Municipal Corporation. During the course of construction, the building is sealed in pursuance of the orders passed by the Commissioner SDMC. The owner disputes it and states that the construction is in accordance with the building bylaws and the building plans sanctioned by the SDMC. What are the remedies available to the owner? Sixth question is, what are the different modes of talaq under the Muslim law and which is considered to be the best or good talaq? Next part 2, attempt any 2 of the following 3 questions. Proof of loss is a sine qua non for claiming liquidated damages. On proof of damages, the person complaining of breach is entitled whether or not actual loss is proved. Only reasonable compensation, not exceeding the amount so named in the contract as liquidated damages or penalty. Explain with the help of the relevant case laws. Whether proof of actual loss is necessary in case of public utility project like construction of a road or project relating to the environmental protection. Discuss. Next, what are the broad principles governing grant of anti-suit injunction? Explain with the help of relevant case laws. Whether a property can be equitably mortgaged by depositing of document which may not be the title deeds or registered document of title but the documents of allotment of land by a cooperative society or a local government authority. Support your answer with the help of the relevant provision of law and case laws. Next part is part 3 and attempt any 4 out of the following 6 questions. And the question is, there is a double-story shop in an upmarket in Delhi which is let out by the landlord L to the tenant T sometime in the year 1955 on a monthly rent of INR 500. An eviction petition under section 14 subclause 1 subclause B of the Delhi Rent Control Act 1958 is filed by the landlord against the tenant on the ground that the tenant has sublet the property and parted with possession of part of the premises by subletting a part of the first floor by letting out 3 small cabins to 3 medical practitioners. The landlord alleged that the 3 MPs had a separate MTNL connection in their cabins. Each of the 3 cabins had a door which could be locked. A local commissioner was appointed at the request of the landlord, who stated in his report that at the time of inspection the cabins were not having any doors, but there was possibility of the doors having been fixed on the cabins. Landlord has established the existence of separate MTNL connection in the name of 3 MPs in the cabin. During evidence, it is established by the tenant that the keys of the main door or the shutter always remained with him. It was he, the tenant, who opened the main shutter of the shop in the morning and closed the same in the evening. It was stated and established by the tenant that he was running a chemist shop in the tenancy premises. The tenant alleged that the MPs have been permitted to use the premises with his permission in order to promote The landlord filed an appeal before the Rent Control Tribunal with the government that once presence of third person was established, it was for the tenant to prove that there was no monetary consideration. Decide the appeal with the help of the relevant case laws. Next question is, H marries W in the year 1996. Out of the wedlock, a daughter D is born in the year 1997. In the year 2014, W leaves matrimonial home along with daughter on the ground that the husband has been treating her with cruelty. W is employed as a teacher in a public school, getting a salary of INR 50,000 per month. Since the time W left the matrimonial home, she is staying with her parent in a DDA flat. In the year 2016, W files a petition under Section 18 read with Section 20 subclause 3 of Hindu Adoption and Maintenance Act 1956 to claim maintenance at the rate of INR 5 lakh per month for herself and daughter D of the parties. D had studied engineering, and during the pendency of the maintenance petition in the year 2020, she is engaged to a doctor working in a reputed government hospital. An application is moved by W to claim expenses for the marriage of the daughter amounting INR 1.25 crores. W has established that H, who is 80% shareholder of a private limited hospitality company, is owning a resort with 5-star facilities and having 52 cottages at Manali. Rest 20% share in the company are held by the close family members of H. W has also established that H owns 2 high-value cars, including a BMW. The company Bloom also owns 4 luxury cars. Bloom has a net profit of over INR 2 crore during the last 3 years and over INR 1.5 crores during 2 previous years before that. On fact, it is established before the court that W was justified in leaving the matrimonial home on account of physical abuse and cruelty meted out to her by H. What are the relevant factors for determining the admissibility and extent of the maintenance to the wife and unmarried daughter? Whether the wife is also entitled to any amount towards the marriage expense of daughter D? If so, how much? Decide with the help of the relevant case laws. In this regard, the very recent landmark judgment Rajneesh versus Neha was decided by the Supreme Court, so that will be relevant for this question. Next question is, an owner of a land executed an agreement to sell with X for a total sales consideration of INR 56,000 in the year 1986. X paid INR 25,000 as part of sales consideration at the time of execution of the agreement to sell. The sale deed was agreed to be executed within 2 years. Meanwhile, at the instance of the owner, the period of 2 years was extended twice. Last such extension was granted in the year 1991. A further sum of INR 15,000 was paid by X towards sales consideration at the time of second extension. At that time, balance sale consideration of INR 16,000 was also agreed to be paid at the time of execution of sale deed. However, in the year 1994, the owner sold the land to P and also executed the sale deed despite receiving INR 40,000 from X towards sales consideration. P is closely related to X and is aware of the agreement to sell between the owner X. X filed a suit for specific performance against the owner as well as P. Both the trial court as well as the first appellate court decreed the suit in favor of X. However, the second appellate court reversed the concurring finding of the courts below on the ground that there was no specific averment in the plaint as required under Section 16 subclause C of Specific Relief Act 1963, and the relief of specific performance is discretionary in nature. X approaches the apex court stating that his readiness and willingness to perform his part of the contract was writ large from the payment of the substantial part of the sale consideration. and his conduct. Decide taking into consideration the relevant provisions of the SRA 1963 and the case law. Basically, this is relating to section 16 subclause C of SRA and section 10 of SRA. Next question. Sohan Lal owns a parking space adjacent to a 5-star hotel where Rohan parked his car for a nominal fee. Rohan is issued a parking slip with an owner's risk clause. Rohan's car is stolen from the parking space. Since the car is insured, the insurance company settled Rohan's claim, and in turn Rohan executes a power of attorney and a letter of subrogation in favor of the insurance company. They both file a suit against Sohan Lal seeking payment of the value of the car and compensation during the period Rohan remains without a car. Discuss the liability of the Sohan Lal. Would it make a difference if Rohan had given his car for valet parking to the hotel staff who had ultimately parked it in the parking space owned by Sohan Lal? While handling over the car for a valet parking, Rohan was handed over a parking slip stating that the parking would be at least guests on risk. The suit for recovery of the value of the car and the compensation is jointly filed by the insurance company and Rohan against the hotel. What would be the liability, if any, of the hotel? Refer to the relevant case laws. So the same question is asked from two different perspectives. Next question. L, an owner of the agricultural land, passed away in the year 1951 as the only son of L. G inherited his entire property. G had 3 sons. In the year 1964, G effected a partition by way of court decree and divided his property equally among his 3 sons. G passed away on 15 July 1970. One of the G son, being D, had only one son, A, who was born in the year 1985 through his first wife. D purportedly sold his entire share of property to H by 2 registered sale deed dated 1st November 1999 for an ostensible sale consideration of INR 4,87,500. On 21st September 1999, the 2 sale deeds were sent by the sub-registrar to the collector for action under section 47A of the Stamp Act 1999 as the sale deed were undervalued. Before the collector, both D and H admitted that no sale consideration was exchanged for the sale deed and the amount was mentioned only for the purpose of registration. D got married to H in 1999 and subsequently in the year 2000 the collector held that the 2 sale deeds were executed without any monetary transaction. On becoming major in the year 2004, A filed a suit against his father D and H for the declaration that the suit property was co-personal property. Hence, the 2 sale deeds executed by his father D in favor of H were illegal, null and void. A also praised for a permanent injunction restraining H from further alienating, transferring or creating a charge over the property. During the pendency of the suit, H sold the suit property to P by the sale deed dated 30 October 2007. In the year 2011, the suit was decreed in the favor of A. It was held that the suit property was ancestral co-personal property of D. H failed to prove that D had sold the property for either legal necessity of the family or for the benefit of the estate. Consequently, the sale deeds executed by D in favor of H were held illegal, null and void. Now, H along with P has challenged this decision, stating that A has no locus to institute the suit since the co-personal property ceased to exist after G partitioned the property between his 3 sons in 1964. A contention has also been raised that A had no right to challenge the sale deeds executed in 1999 on the ground that the sale consideration had not been paid, since only the executant D could have made such a challenge. Decide whether the suit property was a co-personal property or it was self-acquired property of D. What is the validity of the sale deed executed by D in favor of H in the year 1999 and subsequent sale deed executed by H in the year 2007 in favor of P? Refer to the relevant provision and the case laws. So this is relating to co-personal property, Hindu law. Next question. W, a Muslim, purchased 2 plots of land in the year 1960 and constructed a house on it. In the year 1967, the house suit property was mortgaged by W in favor of J for a sum of INR 11,000. After 3 years of execution of mortgage, not being able to pay to J, W executed a registered sale deed dated 21st December 1970 in favor of J for a consideration of INR 30,000. In the year 1978, S, son of W, filed a suit against J for declaration that the mortgage deed dated 21st November 1967 and the sale deed dated 21st December 1970 in favor of J is void and consequently sought cancellation of sale deed. In the alternative, S also claimed for redemption of the mortgage in case the mortgage is held to be valid. It is the case of S that the suit property was gifted to him by W through an oral gift deed dated 30 September 1970 and he was put in the possession. On the very same day, a will was also executed by W in favor of N, stepmother of S, in respect of certain other properties which clearly mention about the oral gift. S also averred that the sale deeds were executed by W under undue influence and the consideration was also inadequate. During evidence, it is established by J that W had sold the suit property for consideration of INR 30,000 and executed the sale deed, post which she had continually exercised her ownership. In fact, based on the registered sale deed, J had been filing eviction petition against various tenants. One such eviction suit was filed by J against S and N also, which was declared in her favor, and against SNN. The appeal filed by SNN against eviction order was also dismissed. J also averred that the suit for declaration was barred by limitation. The suit property was mutated in the name of the J after 4 years of execution of sale deed. During evidence, S had admitted the fact regarding eviction order and mutation of the J's name in the municipal record. The trial court thus dismissed the suit for declaration, holding that the mortgage deed was legal and valid. It was also held that the sale deeds were executed on payment of due consideration and cannot be assailed on the ground of undue influence or inadequate consideration. The suit for declaration was also found to be barred by limitation. In regard to will, the trial court held that will cannot be accepted since it does not bear the signature of the scribe and was not registered. The decision of the trial court was appealed by as the first appellate court rejected the finding and overturned the decision of the trial court. It was held that there was no necessity for W to mortgage or sell the suit property for such inadequate consideration, and J had failed to discharge the burden cast on her of proving that the sale deeds were validly executed. It was further held that the oral gift and the will have been duly proved. The High Court affirmed the finding of the first appellate court. The High Court also held that S is entitled to redeem the mortgage and directed him to pay INR 11,000 for redemption of mortgage and also ordered delivery of possession. Decide whether the High Court and the first appellate court were right in accepting the case of S that W orally gifted the suit property to him and also executed the will on 30 September 1970 in favor of N and rejected the sale deed dated 21st December 1970. Whether the High Court was right in granting the alternative relief of redemption of mortgage deed. Next question paper is Civil Law 2. Write short note on any 4 of the following 6 questions. Distinction between the action of infringement of trademark and action for passing off. The concept of res judicata and estoppel. What is the effect of non-registration of a document which require compulsory registration under the Registration Act 1908? Its effect and implication on the continuity of the proceeding before courts and tribunals. Section 52 of the Copyright Act 1957 provide for certain exceptions to infringement of copyright, and the said provision allow limited use of copyrighted work without the permission of copyright holders. What are the acts which are not to be treated as infringement of copyright? Next, discuss the principle and the scope of primary and secondary evidence. Give 2 examples of each. Next, registration of trademark subject to disclaimer and its effect. Explain whether any remedy for injunction would still be available as per the law. Next is part 2. Attempt any 2 of the following 3 questions. Explain when foreign judgment are not conclusive and under which circumstances there could be a presumption as to the foreign judgment. Quote relevant provision of law and give 2 examples. Next question. Is the object of section 9 subclause 1 subclause 2b and section 17 subclause 1 subclause 2b of the Arbitration and Conciliation Act 1996 similar to the object of order 38 Rule 5 of the Code of Civil Procedure 1908. Please explain whether and under what circumstances and situations the court or the arbitral tribunal can exercise its power to pass order in order to secure the amount in dispute. Give 2 examples. Explain the following principles on which section 91 and 92 of Indian Evidence Act 1872 are based and difference between them. Please explain by giving 4 illustrations. Part 3rd. Attempt any 4 of the following 6 questions. The plaintiff filed a suit for recovery of amount against defendant in the year 2016 in Delhi court. In his written statement, defendant has taken the objection about territorial jurisdiction. Despite the objection, plaintiff continued the suit. Issues were duly framed, including the issue of territorial jurisdiction. Evidence led and the suit was finally decreed in the year 2020. At the first date of hearing of appeal, the plaintiff withdrew a suit to file a fresh suit in the court having territorial jurisdiction in Mumbai. An objection was raised by the defendant that the suit was now time barred. The period spent by the plaintiff in the earlier suit cannot be excluded under Section 14 of the Limitation Act 1963 as it was not prosecuted with due diligence and in good faith. Please discuss the law and give reasons as to whether the period spent in the earlier suit can be excluded under Section 14 subclause 3 of Limitation Act, or it is the discretion of the court to exclude or not to exclude the said period. Next question. The plaintiff filed a suit for the passing of its trademark and its infringement of the copyright. The defendant filed a written statement claiming 4 years continuous use of the same mark and copyright within the knowledge of the plaintiff. The defendant pleaded long delay, acquiescence and the estoppel in view of positive knowledge of such use of the plaintiff. Admittedly, the defendant was working with the plaintiff. The defendant was also unable to explain the reason why he had adopted a similar mark and copyright. Please discuss the law and decide the application for injunction, giving reasons as to whether the plaintiff is entitled for injunction or not. Next question. A, who is the owner of property at Lajpat Nagar, New Delhi, executed agreement to sell on 25th January 2017 with B for sale consideration of a sum rupees 5 crores. B paid 10% as advance of sale consideration. The agreement to sell was neither stamped nor registered under Registration Act. The possession was never transferred by A to B at the time of execution of document. After expiry of 2 months, A refused to sell the property to B in view of the better offer received from C. B had no option but to file the suit for the specific performance against A along with the prayer for injunction and for damages. The suit was strongly contested before the court by A, who also filed an application under Order 7 Rule 11 subclause D for the rejection of the plaintiff on the ground that the suit was barred by law. Please discuss the law and decide the application filed by A for the rejection of the suit as to whether the suit is barred by law or not by giving reasons. Next question. The plaintiff filed a suit for infringement of trademark and copyright against the defendant in the City Civil Code, Hyderabad. Being suit number 238 of 88, the court dismissed the suit mainly on the ground that there was no infringement. Thereafter, second suit number 123 of 1992, including a fresh prayer for the relief of passing of action, was filed. It was alleged in the second suit that the same was being filed on the basis of fresh and recurring cause of action. The defendant has denied any passing off and also alleged that the second suit is not maintainable and is barred by Order 2 Rule 2 subclause 3 of CPC. Plaintiff denied all averment of the defendant and stated that it is not barred under Order 2 Rule 2 CPC. Please discuss the law and decide whether the second suit is barred under Order 2 Rule 2 subclause 3 CPC or not. Also discuss as to whether it was a fresh and recurring cause of action or whether the second suit is maintainable or not. Give reasons. Next question. The claimant filed an application under Section 31 subclause 6 of Arbitration and Conciliation Act for passing an interim award on the basis of admission about completion of work at the site made by the respondent in the statement of defense. The prayer is opposed by the respondent stating there is no specific admission in the statement of defense. Now the said application has to be decided. Admittedly, as per the scheme of Section 31 subclause 6 of Arbitration and Conciliation Act, court and arbitral tribunal are empowered to pass interim award on the basis of fact and admission made by the respondent. On the other hand, the provisions of Order 12 Rule 6 of CPC require an unequivocal, unconditional and unqualified admission by the concerned party. In view of the above fact, decide the application and explain the distinction between the scope of Section 31, Subclause 6 of Arbitration and Conciliation Act and Order 12, Rule 6 of CPC. Next question is: A is a well-known author who had written a Hindi novel. B is the director of Hindi movies. A assigned all right pertaining to copyright in its novel in favor of B, who intend to make a Hindi movie of the theme of a novel. After completion of the movie and before its release in theatre, A filed a suit for injunction and compensation against B. The complaint of A was in respect of mutilation and distortion of the theme of the novel. Such details were provided to the court. B denies all the allegations. His defense was that there were merely cosmetic changes in the theme of the novel as per usual practice in the film industry. The controversy before the court was the question of demarcating the boundaries of the rights of the author A, despite assignment of copyright, and that of the director of the film B, who had spent huge sum for making the movie. In view of the above fact, decide application for injunction as to whether B has violated the moral right within the meaning of Section 57 of the Copyright Act 1957 and whether A is entitled for injunction or not. So now next question paper is criminal law paper. Write short note on any four of the following 6 questions. In a case involving 2 or more accused, it is permissible for the court to record their joint statement under Clause B of subsection 1 of Section 313 of CRPC to save its time. Next, when can power under subsection 1 of Section 319 CRPC to add and summon an accused can be exercised by the court? Next, will the medical evidence in sexual offences favouring the accused have any impact on the ocular testimony of the prosecutrix or other material witness or evidence of a person to whom the prosecutrix immediately after the incident narrate the facts? Is there any presumption of correctness attached to the confessional statement recorded under Section 164 CRPC by the magistrate? Next, consideration for awarding sentence to a convict. The legitimate expectation of a victim of a crime from the state. Next is part 2. Attempt any 2 of the following 3 questions. Can an accused be convicted on the sole uncorroborated testimony of an accomplice? Explain. Defense of alibi and the burden of proof. Explain. Is there any requirement of issuing notice to an accused before arrest in commission of cognizable offence? Elaborate. Next is part 3. Attempt any 4 out of the following 6 questions. The marriage of A and B was solemnized on 2nd November 2016. The accused was their immediate neighbor and wanted to marry A and threatened to kill her if she refuses. On 15th November 2016 at about 4:30 p.m. when A was sleeping, the accused entered her bedroom with petrol in a can and threw petrol on her and set her on fire before running away. A came out of her room crying, engulfed in flames, and upon hearing her cries, her husband B, who was on the terrace, came down and extinguished the fire and took her to the LNJP hospital. The medical officer opined that she has suffered 100% burn injuries. The IO recorded her statement in the presence of PW15, that is medical officer. Later on, PW15 declared the deceased fit to make statement when STM also recorded her statement. Next day, she succumbed to her injuries. The accused was arrested on the same day. On his disclosure to the IO, the accused got recovered the plastic cane and a photo of the deceased from his home. On medical examination of the accused, he was also found to have suffered fresh burn injuries on his both hands. The accused contended that if the deceased had suffered 100% burn injuries, she could not have put her thumb impression on both the dying declaration, and in case of a female, only the right thumb impression is taken. In his cross-examination, the IO explained that the right thumb and the left hand of the deceased were burned, but the left thumb was safe. Discuss the criminality of the accused in this case. Next question. A filed a criminal complaint under Section 138 of Negotiable Instrument Act 1881 against B and her proprietary firm for dishonor of check dated 28th October 2016 of rate 1,92,000 on stop payment instructions. The complainant alleged that he used to supply wooden material to B, and the said check was given to him by B for wooden material purchased via invoice number 344 dated 28th October 2016. A filed a copy of invoice bearing some cutting thereon. B placed on record a copy of letter dated 1st October 2016 addressed to her banker to the effect that she lost her blank signed check in Kasturba Market, where she had gone to buy some goods and for stop payment. She also filed a copy of the complaint lodged with the police after 23 days of having lost her check in Kasturba Market and having given a stop payment instruction to her banker. At the time of framing notice under section 251 CRPC, B replied that the check was stolen by A and A had no liability as she had already filed a complaint to the police. The accused also filed an application before under section 145 subclause 2 of Negotiable Instrument Act that in September 26 the complainant in her absence used to come to her office for business purposes as they had good business relations, and A came to her office and stole the check. B appeared as a witness and testified that the check in question and other check meant for payment or the suppliers by her family members used to kept at her residence come office, as she used to be in the field most of the time. She admitted in her cross-examination that she was having a running account with the complainant and had put the date on the check in question. Decide the criminal liability of the accused. Next question is the marriage of A and B was performed on 5th October 2019. B made a telephonic call on 26th September 2021 at about 1 a.m. to his father-in-law and informed him that his wife A had fallen sick and had to be taken to the hospital. PW1, that is father-in-law, and his daughter-in-law reached the home of B where they found A in unconscious condition. They took her to the nearby hospital where she was declared as brought dead. PW1 refused to give any statement to IO as his son had gone abroad. PW15, who conducted the post-mortem, found the deceased suffered fractural nasal bone and injuries on her right temporal region apart from the nail marks and abrasion on her cheeks and lower part of the back. He observed that the injuries were ante-mortem in nature. PW1 and PW5 gave their respective statement to the IO 2 days after the incident. An FIR under section 498A304B302 IPC was registered against the accused. As per FSL report, the cause of the death was due to the coma caused by cranio-cerebral injury, head injury by means of hard, blunt and forceful impact upon head. The defense of the accused is that PW1 and PW2 gave their statement to the IO 2 days after the incident. There was no evidence of demand of dowry and causing cruelty to the deceased by him. No weapon of offence was recovered from the home. No motive was imputed to him. Casualty card of the hospital did not mention any injury on the body of the deceased. No guard was deputed in the mortuary to protect the body prior to the post-mortem, which was conducted after 2 days. In his statement under section 313 CRPC, he stated that his wife was sick, being anemic, and fell down from the bed and suffered injuries. He admitted that he and the deceased were alone in the home on the night intervening 26th or 27th September 2021. Discuss the criminality of the accused. Next question is, an accident took place between a motorcycle and a Maruti car at about 10 a.m. on 18th March 2021. The motorcyclist became unconscious and a guard posted at a nearby farmhouse brought him on the side of the road and informed the police. The motorcycle was taken to a nearby hospital in a PCR when he was found to have suffered fracture in his right leg and both the wrist of his hands apart from other injuries all over the body. An FIR was registered under section 279, 337, 338 IPC against the car driver. The motorcyclist deposed that he was driving the motorcycle on the left side of the road, and when he reached near the VM farm, he found that accused was driving his car at a very high speed. A loud music was being played inside the car which was audible outside, and his car collided with his motorcycle. He lost his consciousness, and when he regained his consciousness after 5 minutes, he noticed that he was lying down on one side of the road after being brought by the guard of the farmhouse. In his cross-examination, PW1 stated that the accused was driving the car on the wrong side of the road. However, he admitted that the side plan prepared by IO on his instructions to be correct. The IO testified that when he visited the site after receiving information of the accident, he found the motorcycle parked on one side of the road and car on the other side of the road, and accordingly he prepared the site plan. The IO also conducted the mechanical inspection of both the vehicles. The mechanical engineer found both the vehicles were damaged from the front side. Discuss the criminal liability of the accused. Next question. On 10 June 2019 at about 2 am, the complainant, aged about 14 years, heard the loud screaming of her mother and came down to room of her mother from first floor. She found that accused had caught hold of her mother and was pouring kerosene oil from a plastic bottle on her. Suddenly he set her on fire with a matchstick. PW2 started crying loudly, after upon which her uncle PW3 came there from his nearby house. In the meanwhile, the deceased told PW2 that the accused wanted her to sleep with him, to have physical relations with her, which she refused. The accused fled away by jumping the wall. The deceased was taken to LNJP hospital, where the medical officers found that the deceased suffered 100% burn injuries but was fit to make her statement. The deceased made similar statement to PW5 that the accused wanted her to sleep with to establish physical relations, and on her refusal he poured kerosene oil on her and set her on fire with the matchstick. The deceased succumbed to her injuries 2 days thereafter. PW2 and PW3 supported the case of the prosecution, but the defense argued that the FSL report ruled out smell of kerosene oil. Fingerprints did not match with the accused. PW2 did not state to the IO that the fire was extinguished by PW3 by putting a blanket, and it was a case of suicide. The accused does not explain in his statement under section 313 as to how he suffered burn injuries on his person, as his LMLC recorded fresh burn injuries. Discuss the criminality of accused. Next question is A. The complainant A and the accused B entered into a loan agreement on 1st May 2017, where the complainant A advanced a loan of 2 lakh to the accused B, and the loan was to be repaid by B on or before 31st December 2018. The complainant A demanded the return of loan amount in the 3rd week of December 2018. To discharge his liability, the accused B handed over a check of 2 lakh dated 26 December 2018 to A. The said check was dishonored for insufficient fund. After giving notice to B, the complainant A filed the complaint under section 138 of Negotiable Instrument Act 1881. The defense of the accused were: A had in fact advanced him loan of 1,76,000 only, and at the same time he gave a blank signed check to A. There was no subsisting liability against him. He had given the check to A as security. The recital of the loan agreement mentioned that A had agreed to give a loan of rate 2 lakh to B on interest 2% per month. As per the terms of the loan agreement, rate 2 lakh included interest 2% per month. A admitted in his cross-examination that he had provided a loan to B by a check of rate 1,76,000, and A further voluntarily stated that he had also paid cash amount of rate 24,000 to the accused at that time. Decide the complaint. So this was the question paper of Delhi Judicial Services 2022 mains examination. I hope this video will help you. Thanks for watching.